work with us today. We're not sure we have the right platform for this because of the number of people that actually signed up today. Normally, we're doing this presentation to 5 or 6 people, and it's on a very informal basis. Since we've opened up the roles, we were surprised how many people signed up to participate today. So we anticipate we're going to have a little bit of growing pains with addressing, questions that we might have and how we're going to handle the timing. So what I would encourage folks to do is, send me some questions through the chat as you go, if there are questions. Christine McAllister, who I think probably most of the folks on the phone have dealt with at one time or another in our office, will try to kind of sort through the chat, the questions, and throw them to me as we go. We're also recording this. We're not sure whether that's something that makes sense to kind of make available to people. If there's more interest, we'll just do it again. We'll do other subjects now that we know that there's actually a great interest in that. So with that said, what I thought we'll do is we'll just kind of kick this off. I have a number of slides. You should be able to see my screen. It does say that I'm sharing my screen, so if you can't see it, somebody let me know. And we'll start to run through these slides. And yeah, if anybody would like to get copies of the slides afterward, we're happy to provide them. And I'll do my best for anyone that called in and can't actually see the screen to kind of read through the slides. So I'm going to kind of kick that off. And what we typically talk about with the basics of community association, and keep in mind this seminar is kind of tailored for new board members. So if you've essentially kind of recently been elected, this is the type of course we go through. They're going to give you the 101s of basic community association. And so community associations, just by way of history, how did they come about? And what you'll see by way of history is typically community associations and condominium associations really started to pop up and become popular late 50s, early 60s moving forward. And what we believe that is a result of municipal governments trying to shift the maintenance of parks and recreation space away from cities or from counties to community associations. So encouraging communities to have their own open public space and to actually manage that space. And so as a result of that, community associations have a couple characteristics. Usually it's a mandatory membership. So before a lot is sold in a community, governing documents are often recorded that obligate everyone that owns a lot to be a member. That gives the association then power to regulate, meaning adopt rules and regulations, power to assess, charge money, and then it imposes upon your community associations the obligations to protect assets and provide sometimes services, so sometimes utilities. So that's kind of the 101 version. Well, why do communities exist? But what's really unique about community associations and why it becomes a real struggle for a lot of new board members to kind of get their hands around what their job are is that community associations are kind of a dual purpose. Essentially, they serve a business role and they serve a government role, which is not something that truly exists out there. So when you think about a business, let's assume a for-profit corporation, they have certain confidentialities. They don't have open board member meetings, but they do provide some sort of services and they run board functions and expenditures. And that's the kind of thing that the business function of a community association is supposed to do. But you have to couple that with what a community association has similarities to a governmental role. And that's what we kind of say that there's a sunshine component to community associations. Because they were created by state law, because they have these powers to regulate and powers to adopt rules and regulations and to enforce, we think they're quasi-government. And as a result of that, quasi-governments should have some sort of transparency and some sort of ability for its members to look over the shoulders and see that people are doing right. Meaning the body is electing the directors to run the association, and much like your governmental entities, the body should be able to kind of watch what's being done in an open and a transparent format. So that's kind of the 101 version. Why do community associations exist? Kind of how is some of their structure? So now let's start to get into some of the meat of this presentation, which is what are the fiduciary duties? So when you, and I think most of the folks here on the call are directors of their community association. When you volunteered for that position, did you recognize the fiduciary duty that you were going to be stepping into? So I can give you a really easy and legal definition of the fiduciary duty, and I'll just read through it really quick, and then we're going to kind of like dig into it and break it apart. The fiduciary duties of board members must discharge their duty in good faith with the care as a ordinary prudent person in a like position would exercise under similar circumstances in a matter that the director reasonably believes to be in the best interest of the association. So essentially that's kind of our easy legal definition. And what I also say, and I've got a sentence here that kind of talks about they're responsible for their conduct and for failing to act. So when we talk about breaches of fiduciary duty, we put them in two big broad categories. I call them acts of commission or acts of omission. So acts of commissions are I did something, but I did it wrong. And the acts of omission are I should have done something and I failed to do it. And those are the two categories that under Delaware corporate law and Maryland corporate law as well, that a director can get in trouble for fiduciary duties. And that does remind me, for the most part, my comments are going to be generic, whether you're one of our Delaware clients or one of our Maryland clients. But if there are differences, I'll try to make those distinctions as we go through. So what does fiduciary duty look like? So now we're going to start to really kind of break it up. And what I often say to my directors is, you really have been elected to do one job as a director. And what that job is to make decisions. How do you make decisions? You vote. Either you participate in your board meeting and you vote on a particular topic, you vote against it, you make motions. That is your job in a big, broad category. But then how do we start to really kind of get down to the nuts and bolts of running the association? So this triad of duties is the type of thing that you should think about as you work through every decision, because that's your job. Make decisions. So the triad of duties is a duty of care, one of due diligence, duty of loyalty, not to do self-dealing, and to act within the scope and authority of your documents. We're going to break these down just a little bit more in detail for you. So let me move on to the duty of care. So this is a duty that the director is going to act with the amount of care that a reasonable and a careful, prudent person would under similar circumstances. And this is good. This is a very high standard under Delaware and Maryland law, that you really won't be held liable as long as you don't act in a negligent manner or act with reckless indifference. So it's a very high standard and it's useful. Now, how do we kind of really, I know those are concepts us lawyers like to throw around, but how do we really start to apply that? What does it look like? And that brings us right into something called the business judgment rule. And this is a good rule for the directors. It's a rule that evolves through corporate governance for the for-profit world. And the way I kind of shorthand this rule, which is, as long as you're making your decision, you could have made the wrong decision and you will be protected from liability from making the wrong decision, so long as that decision was made for the right reasons. I know that's confusing, but really, essentially what we're saying is your job requires you to act on a well-informed basis and in the best interest of the association. So as long as you do the things that help you become well-informed and you're acting in the best interest of the association, the law will protect you if down the road, in hindsight, it appears that you made the wrong decision. And the technical component of that is that the business judgment rule essentially puts a really high standard on a plaintiff suing directors for a breach of fiduciary duty to say that they failed to act on an informed basis or they failed to act in the best interest of the association. And these are pretty helpful rules, they're very useful. So that is the duty of care. Now, the duty of loyalty is the next duty of loyalty. And this is probably one of the most common issues that directors bump their heads up against, which is, am I acting in the best interest of the association? And we'll often shorthand this one to say, is the decision you're making benefit you personally in a way that is different or better than the majority of the members in your communication? And, you know, in this format, it's a little tough. I like to throw out questions as we go. But so I'll say to you, think to yourself, is it okay for the community association board to retain a contractor that is, say, for example, the brother or brother-in-law of a board member? Normally I'll wait for the answer. You know, either the answer is yes or the answer is no, depending on what people think about it. And what we often say is, well, there's no actual rule or statute that would prevent that. Is it a conflict of interest? Well, maybe it is. But that's where we say that you have to really start to dig into some of those decisions and determine, is there a benefit that's being derived to a particular board member that is in their own personal self-interest? So if there is some type of component to a transaction that could benefit a director more so than the rest of their constituent groups, we say, well, you're kind of in that zone. Be very careful, because you may be breaching the duty of loyalty because you are potentially putting your interest and your welfare as a director ahead of someone else. And so that's kind of where we see the vast majority of questions come in about breaches of fiduciary duty. And I'll just kind of stop and pause here, because I'll often get a question from boards of directors saying, well, isn't so-and-so conflicted and they can't run for office. I think I've had some before where, they have a relationship on a township commission, or they have some sort of relationship to the developer in the past. And what we'll often say is, a relationship doesn't automatically conflict you from being a director. Instead, you have to look at every decision on a decision-by-decision basis as to whether or not there's a conflict of interest and whether or not there's a duty of loyalty question. So do think of it that way. Every decision that you're about to make, you have to kind of run it through these three triads: the duty of care, the duty of loyalty, and that final one that I mentioned, and I don't have a slide on that, is the duty to act within the course and scope of your document. So essentially, is the decision you're making something that you're authorized to do in your governing documents? So those are the three things that we kind of want you to kind of run through as you're making each decision. And so that's essentially the fiduciary duty. And, forgive me, that was the real heavy legal stuff that I wanted to throw at you, so I'm throwing it out in the beginning. So let's kind of move on. So the rest of the presentation is going to be talking an awful lot about the best practices for a director as we start to move through some of the decision making. So what is my role as a director? So if you remember earlier, I had said, well, your job as a director is really make decisions. Well, what do some of those decisions relate to? And I put together a slide of some of the most common decisions that directors deal with: establishing policy and adopting rules and regulations. So in my practice, I spend a lot of time talking with those of you here on the call about some of those concepts: adopting rules and regulations and policies. Some of the other ones are operational decisions. Which vendor are we going to do? Which particular pool modifications are we going to do? One of the other things is attending all of your board meetings. Next is being familiar with and dealing with all of the financial statements. And next is also discussing liaisons and working with management. And I have a slide later on where we're going to talk a little bit about what we think is the healthy allocation if you use a professional management company. What are some of the other ones? Planning for administrative tasks, and then finally establishing committees. And so I have some communities that use committees very well. I have some communities that the board does all of the work. There's no right, there's no wrong, there's just kind of what works for your community. And as a director, you should think about how best to use that. All right. So this slide, I'll admit, I've kind of harvested from some materials I've read about in CAI, and this is kind of things to think about as what they think to be effective directors. And there's a laundry list here. I'll read through them because I think there's some folks that called it and didn't look at the slides, but lead by example, be prepared and informed, strive to achieve structure and order, professionalism, seeking expert advice when you need it, establishing priorities, community involvement, committee involvement. We often say having prior committee experience is a great path to being on the board, communication, and leadership. So this is our list of the things that we think are effective leaders. And what we'll often stop and say, well, what do you think should have been on this list that's not there? And one of the most common examples we get is experience. Should you have experience running boards or being on boards and doing those types of things? And what we'll always say is that always helps, but it shouldn't be considered a limitation, because the willingness to learn and do all of these things will make you eligible to be the director and an effective director if you work through what you see on this list. Look just to make sure I don't see any questions coming through the chat box yet. So some of the other things that we talk about, what is the standard of conduct for a director? And keep in mind, these are not statutory standards. These are things that I'm pulling from some of the literature and what we think makes for a good, well-run community association and is transparent. So what I encourage when we do these board leaderships is, try to pick some of these things. These aren't my list. I've pulled these lists from other literature that I've read, suggesting how community association boards can run effectively. So some of the standards to think about is to act as a representative of the entire community. So always think when you're a director is, I don't just represent the folks on the east side, or I don't just represent the folks in phase 7 where I live. I represent the entire community. And I have some communities with multiple neighborhoods, and you have to remember that you represent everyone, not just people from a certain neighborhood. Next, maintain confidentiality of information. it's very easy to start to release some confidential information that you obtained as a board in a form or a format that it probably shouldn't be for dissemination. So always think about, what is my obligation? And we encourage folks to consider in a board to adopt a policy of conduct. CAI has a great sample policy out there that does address confidentiality of information. What's in the other? Refrain from using the board powers for personal benefit. Now, we hate to see those types of things. I'm sure that there's a lot of horror stories out there that some of the folks on the call can tell us, but it goes without saying that it makes sense to not utilize that position for your own personal benefit. Also, act respectfully towards others. CAI, Community Association, has been working hard over the last couple of years to try to bring about awareness of what we seem to be seen as a lack or a slide of civility. A lot of the blame we put on social media. It seems pretty easy to hide behind our keyboards, make social media posts disparaging others that we may not have said to somebody in person. So we often want you as a director to kind of try to rise above that, try to stay above the fray and be respectful to others in all circumstances, and recognizing as a director, they're kind of expecting you to be held to a higher standard. And then finally, avoid legal misconduct, and so that's where you would want to consult with professionals when you have issues to deal with to proceed in that way. Let me see, I have one question here in the chat about how to involve others. And so I kind of breezed over that, but when we teach, and by the way, I teach a CAI seminar that runs 8 hours, and we spend a whole module on volunteerism. And there's a number of potential opportunities there are for volunteerism, but the definite encouragement is committee involvement, as well as, finding tasks for people to get involved in. So sometimes assisting with minutes and sending out newsletter. Those are the types of things that you can use to kind of encourage volunteerism. And let me see, I have one other one, which is, would being a realtor be a conflict of interest serving on the board? And I think I chatted a little briefly about that, in that your position doesn't conflict you from serving on a board of directors. It's a decision by decision. So let's take that realtor that is serving on the board, and let's assume that they're trying to sell the property. They may have a violation, and an issue comes before the board about what to do about the violation. That's a situation where that realtor now has a conflicted interest. They want to see that sale go through, but they also have a duty as a board member to deal with violations. And that would be a situation where that particular director should say, I'm not going to participate in that decision. So it's situation by situation, issue by issue. Let me see. Somebody else said, can chats during meeting be added to the minutes? I got a slide on minutes, so I'm going to skip that question for now. We're going to get around to that in a minute. All right. So one more slide here about the best approach for new board members. So this is the slide we put out. This is the first time you've ever been on a board. These are some things to think about. If you've been on the board for years and years and years, you can ignore this one. And that is, first, listen and learn. So kind of watch how things go. Listen and learn before you really jump in and start changing things around. Learn the history, gain the knowledge, read through the old minute books to see what has happened over the last couple of years. Research issues, don't just make assumptions. Read all the management policies and procedures. We always encourage our boards once a year, you should review all of your policies and procedures to see if they should be tweaked or modified. And then be familiar with the financial statements. Because then that leads into this next one, which is, well, what are some of the nuts and bolts decisions that our directors are going to be expected to deal with as they start to do their jobs? And here's the list that we've put together on this slide. Maintaining the records, and that will fall. We're going to have a slide where we're talking about the secretary and what their jobs are. Adopt the budget and collect assessments. We're going to talk a little bit about the nuts and bolts of what a treasurer is going to do. Do year-end financial requirements, and that may be the budget process, or it may be closing out the books. It may be doing write-offs for receivables. Running the annual meeting, and note, we're going to talk a little bit about the differences between an owner meeting, an annual meeting, or a board meeting a little bit. We're also going to talk, one of the other administrative tasks you deal with, and I spend a lot of time with my boards, is adoption and enforcement of rules and regulations. The other one is planning reserve studies, and I think somebody had submitted a question ahead of today's seminar about reserve studies. And just to say out there, there is a requirement in the Delaware statute that condominiums have a reserve study every 5 years, and they be fully funded under that reserve study. And there was a catch-up period where condos were allowed to pay slowly over time, but that expired in February of 2017. So if you're a condo, you should be fully funded by now. And a lot of other HOAs, non-condos, in their governing documents have a requirement for reserve studies. So you should take a look at that and be aware. What are my tasks? What do I have to do? And then the last administrative task is contract management. And I can tell you we talk about that a lot at some of our CAI seminars, which is I know a number of the property managers have a tool that they manage contracts by. When do they expire? When are the renewal terms? Are there fees that go along with it? And so just because you've signed the contract, you shouldn't just throw it in the drawer and forget about it. You actually have to manage it and make sure that people are complying with it and that you're hitting all the deadlines as things start to roll forward. So that's kind of my recap of, well, what's my job as a director? And let me just take a quick peek to see if I see anything in the comments before I move on to my next topic. Okay, so I have a question about owners commenting at the board meeting, so I'm going to cover that in another slide, so I'm going to wait on that in just a little bit. So let me talk about officer positions. And so I have a lot of new board members that sometimes confuse the concept of a director and an officer, and these are different things under our law. So what typically happens, I'm going to say typically, we often have to go to your governing documents to know the exact answer because sometimes it will vary, that the members will vote at the election and elect their directors, 5 directors, 7 directors. And each one of those directors gets 1 vote on an issue, usually the majority vote controls. Normally, the directors then have their first meeting and they do their own election, and the directors decide who's going to be the president, who's going to be the vice president, who's going to be the secretary, who's going to be the treasurer. And that's for the directors to decide, not the owners to decide. I have a lot of communities that just think that, well, now we're electing Jane over here to be the president. Well, no, typically you're electing Jane to the board, then the board decides who the president is. And as it follows along with that same concept, those positions can change. So if the president is not doing a good job, well, at the next meeting, any director can make a motion to remove Jane as president, and we'll put somebody else in. And that can change from time to time depending on how that's going. So I wanted to talk a little bit about, all right, now that we know the distinctions between an officer and a director, let's talk about what are the jobs. And the president's job, as you might imagine, has the most to it. What you're not going to see on the slide that I just put up on the screen is the president doesn't get a veto. The president's vote doesn't count anything more than a director who's at large and doesn't have an officer position. All it means is the president has a lot more work that they've stepped into and have agreed to do between meetings. And what's on that list? Well, that's to lead the board. How do you lead the board? Well, you preside over meetings. You're the chair of meetings. You make sure that the meeting agenda is done ahead of time. You may help prepare the budget. You may work with your professional partners. You may be the person that the board directs to execute a contract when it's time. You might oversee committees. You may have to attend the committee meetings. You might have to oversee the enforcement procedures. So the president is essentially the person that's hands-on doing all of the work that the directors voted and told that person to do. So do keep that in mind. This is kind of our list of the president's job. And I got to tell you, my favorite job is coming up next. It's the vice president's job, because you know why? The vice president, all they have to do is be prepared to step in when the president is not available, right? So how hard is that? And they get paid the same amount of money, same salary as the president. So it's the best job, pays the same. That's what I always say. So that's just it. The vice president's job is really just to be there and ready to step in when needed. The secretary, on the other hand, lots of work there also. So the secretary is responsible for the minutes. And when I say responsible, it doesn't mean the secretary has to take the minutes. I have a lot of communities that the secretary is responsible to make sure the minutes are getting taken. Now, they could be hiring a company to do it. They could be making a management company do it. They could have another volunteer taking the minutes. They just have to make sure the minutes are getting done. They don't have to be the one and the scrivener on the minutes. The secretary is also responsible for doing the meeting notice, maintaining the association's documents, doing a membership directory if you do one, managing correspondence. So the secretary has a lot of jobs. What about the treasurer? The treasurer has a lot of jobs too. So the treasurer also has to maintain all the financial and accounting records. But let's go back to kind of that same concept I was saying with the secretary and the minutes. Most of my clients are professionally managed. So most of my treasurers, they're just supervising or making sure that the management company or the manager is doing the right thing with the financial records and the accounting records. So the treasurer doesn't have all the records at their house, but they're responsible to make sure that they are protected and that the right things are being done. And so what else does the treasurer do? Oversees investments. So if you're a community with large reserves, and you have an investment policy, the treasurer often will be the head of that committee dealing with any investments. The treasurer is also responsible for overseeing the assessments and the collections, typically for preparing the budget, also for making sure the tax returns get filed, and then working with the financial professionals. So the treasurer has a pretty sizable job as well, whoever that person may be. And one point to note, and I don't really have a slide on this, but the vast majority of governing documents, so it's either going to be a bylaw if you're an HOA or the code of regulations for our condominiums, the vast majority of bylaws only require the president and the vice president to be directors. Often the treasurer and the secretary do not have to be directors. So your treasurer and your secretary could simply be other members within the community that have a good skill set, such as they have a good skill set to be the treasurer or the secretary, and they volunteer to do these jobs. So what happens is at board meetings, they're there to participate and provide their guidance. But when it actually comes to voting, if they're not a director, they don't vote. They're just doing the work, and the directors still do the vote. So I would throw that out there. I have a number of communities where the treasurer or the secretary are not elected directors, but are just people with that skill set to do that type of work. So where does that bring us? All right, so that's kind of the end of that slide. I'm actually 2 minutes ahead of schedule on my slides. We have about 40 slides. I figured that would be about 10 slides every 15 minutes. So I'm moving right along. I'm hoping to kind of squeeze up a couple of minutes so that we can kind of take on any other questions at the end if we have any. And let me see, I see one or two here in the chat box. So before I move on to the next topic, what is the director's role in enforcing COVID rules? So the general response we've been dealing with is typically we encourage you to leave to the government entities the enforcement of whatever the COVID guidelines are that the governor has enforced. But when it comes to your clubhouse, your amenities, your pool, you probably have to adopt some type of rules to address COVID restrictions, and the association is responsible for enforcing its own rules. Let me see. Never covered those. And then what about reserve studies? How is it determined? Okay, so I had a question on reserve studies. I don't want to take too much time on that because I think I've done seminars on reserve studies where we talk a couple hours. Almost every reserve study will have a funding component to it, meaning it'll have a methodology in the end, and it'll give you 2 or 3 options on how to fund a reserve. And you'll probably want to work with your reserve professionals because there are multiple theories. There's a component plus a reserve. There's a number of different theories of how to fund it, all depending on how large or small you want the surplus to be. So whoever's asked this question about funding reserves, if you have not seen one, get a sample reserve study from whoever you're going to retain and look at how they recommend the funding methodology. It's a mathematical calculation with lots of charts. All right. So that brings us to source of protection. So I put this in here because everyone probably signed up for the job and didn't necessarily say to the association, well, hey, as part of running for the directors, can you confirm for me that I have D&O insurance? And can you confirm for me that if I get sued as a director, the association is going to indemnify and hold me harmless? So there's probably a few of you on the video chat that did do that, but I imagine there's a number of you that didn't. So let's talk about the most common protections you get, because unfortunately you can get sued as a director for breach of fiduciary duty. What are the most common sources of protection? Well, what I'll often say is, first, let's manage our risk with insurance. I'll get to that in a second. So that's going to be paragraph number 2 and 3 on this slide. But the reality of it is the vast majority of your governing documents, as well as the state statute, if you're a corporation, some of your condos are not corporations, have a provision that require the association to indemnify its directors from a D&O suit or any kind of claim. But the problem is it'll say after success on the merits. So essentially what happens if you get sued under these provisions, indemnification means if I defend myself and I win, the association will reimburse me all of my costs. So that's a little bit painful because it means you've got to pay your fare up front, pay your lawyers to defend you. A lot of communities' documents also go a step further, and it says, and shall advance and indemnify and shall provide a defense for association. So you want to look at your documents to see, am I one of those communities where the association is going to defend me up front, or is it one of the associations where I got to defend myself and pay all my legal fees, and then if I win, I get the association to reimburse me? But either way, we always say you probably want to manage that risk with directors and officers insurance. Why? Because you'd rather the insurance company to step forward, defend you, litigate the case so that it doesn't have to come out of your own pocket. So we encourage all of our communities to understand, do I have D&O coverage? What does it cover? How much is it for? And what are the common exclusions? And so I've put on here what are some of the common exclusions that we see in D&O policies you should be aware of. If you are sued for defamation, the vast majority of times your D&O policies and your insurance policies will not cover you. They consider that a tort, a personal tort, that if you called somebody a liar and a cheat, the insurance company for the association is not going to step forward and defend you. What are some of the other major categories of things that you don't typically see insurance for? Discrimination is one of those. Illegal acts, I stole money. Intentional acts, that's the I punched somebody in the nose at the meeting, which we would discourage that type of actions as well, because you're not going to be covered by insurance. And then finally, breach of contract. Often breach of contract claims, people assume, well, I've gotten sued for a breach of contract by the landscaping vendor. I'll just turn to my insurance company. And insurance companies will often say, sorry, we don't cover breach of contract. So that's the major categories of how you would go about protecting your personal assets by taking on this position. Let me see, I see one more question here before I move to my next slide. Does the president have any supervision responsibility over the other officers and directors? So I'm going to typically say no. Each officer and director has their own job to do, and they answer to the board of directors as a whole, not to the president. All right, so let me move on. I see what is the board's responsibility to understand and implement the Kiowa guidelines. So, Rick, I saw your question there, but I'm not sure I understand what you mean by Kiowa guidelines. The Kiowa is the statute. Some provisions apply to communities, some do not. All right, so here's my next slide. So I have a couple slides here where I talk about, all right, so let's assume you have insurance in place. Let's assume you have indemnification. That's all the stuff that protects you once you have been sued. Well, let's talk about, well, how do we not get sued? How do we not get sued? Well, that main concept is, well, don't be negligent. Don't do things that get you sued. Well, it's easy for me to say. Let's see if we can start to break that down and kind of help you get a skill set that helps you understand that. So here's a slide. What are some of the active ways to discharge your duties so that you don't get sued? One is know the business of the board, meaning don't just get elected as a director and not participate, not do anything. That was that act of commission. If you don't do something, you may have breached a fiduciary duty. One of the classic examples is there's a ton of violations going on in the community and you just turn a blind eye to it and you don't enforce it, and that's a problem, meaning that you may have breached your fiduciary duty by not enforcing the community's rules and restrictions. What's another one? Know the duties and responsibilities of the directors and officers. So know what your job is. If you took on the role as the treasurer, make sure that the budgets are getting done and make sure that the collection is getting done. If you're the secretary, make sure the minutes are getting done. Don't let a year go by to think, oh, who did the minutes last? And I've had some clients where, it's a problem getting minutes done. Nobody wants to do it. Nobody wants to be the secretary. Well, there are solutions out there. I just found a company the other day that I gave to one of my clients that offers the operant, well, it's remotely, they listen into your meeting, they prepare the minutes for you and they send it to you. And of course, there's a charge for that. But if you can't find a willing member to do it, there's always usually some company out there willing to do it for you. You want to make sure those things get done. What's one of the other ones? Supervise the agents and employee to ensure the duties are properly performed. So if you're using a management company, directors don't turn a blind eye and say, well, it's the management company's responsibility and fault. No, they're your agents. They are doing what you tell them to do. You're responsible to tell them what to do and to manage that process. Now, most of the time, your professional management companies have a ton of experience and they don't need a lot of supervision, but that doesn't mean it doesn't obviate you as a director to make sure that they're doing things right. What about preparing for and attending meetings is one of those things. If you don't attend meetings, you're not doing your job. If you don't prepare for the meetings in advance, it also could come off as not being prepared for your job. And finally, know your governing documents. Read them. Be aware of what some of the restrictions are. Be aware of if you have enforcement policies. Be aware of if you have to give notice before you assess a fine. That will keep you out of trouble if you do things the right way. All right, let me see. Here's some other concepts. Know the law. These types of seminars that we do help you to understand some of the law and some of the issues. I think we've watched some of these questions about fully reserved funds. That's a perfect question to evidence that somebody is seeking out the knowledge of what the law provides and making sure they comply with it. That's the type of thing that you should be doing to address the liability as a director. Making decisions. Don't keep kicking cans down the road. Sometimes the answer is no. Sometimes the answer is yes. But sometimes you just have to make that decision and move on from it. Avoid conflicts of interest. We talked a little bit about that. Maintaining confidentialities is something else we also talked a little bit about. Read the minutes before approving them. I do it myself all the time. I'm on a bunch of committees, and sometimes you don't have time to read the minutes, but that is one of those things you really should be doing. Make sure that they're accurate. And the reason being is once you accept those minutes, they become admissions. So if there's something in those minutes that's inaccurate or an admission of fact that you can't get away from, once you've admitted it, it becomes part of your record and you're stuck with it for a while. Do not admit liability in the minutes. So let's be very careful. I'm going to have a separate slide, I think, coming up on how we should do our minutes. Represent the best interest of the association. Openness and transparency is something to strive for. Exercise due care, be neutral and informed. And then if you reserve studies is something else we talk about, which is if you're obligated to do it, do it. Even if you're not obligated to do it, reserve studies are a great idea because they kind of help you understand budgeting and planning. And the whole purpose of reserve studies is to avoid ever having to have a special assessment. Nobody ever wants special assessments. So rule adoption is what that brings us to. So I have a couple slides here, and my dogs are very interested in coming into the room to say hi to everyone. So rule adoption. Rules may not, this slide, I kind of wanted to give you kind of the ground rules for rules. What should they look like? How should they do? And then I have another slide we're coming up where we're going to talk a little bit about the best practices to actually go about adopting rules. So here's what we typically say for rules. Think about this when you go to adopt a set of rules. Rules cannot violate the current law. So if there's a law that addresses a particular issue, you can't adopt a rule inconsistent with that. And the classic example of that is flying of the American flag. There are statutes that make clear a person is entitled to fly a certain size American flag at a certain location, and we can't adopt rules that tell them they can't. Your rules should serve a legitimate purpose. You have to think about why is this rule here, and is it a legitimate purpose for the association? Is it really something the association has the reason to care about? The rule should be reasonable. We see a lot of unreasonable rules. I mainly see unreasonableness sometimes in fines. A $10,000 fine for the first violation, a court would probably find to be unreasonable depending on what the violation is. The rule should be fair. It should apply to people evenly. Consider the enforcement. Is it really something you can enforce? I've had a number of communities adopt rules that they make a lot of sense, but the only way you're going to enforce it is to have somebody there 24/7 watching, for example, the parking lot or something like that. So think about the enforcement side of it. And of course, make it easy to read. We don't want a 40-page document on rules. We want it to be kind of concise and easy to understand. Rule adoption steps. So once you've kind of concluded that the rule meets all those criteria and we should adopt it, what is the best practices? And I'm going to say best practices because in Delaware, what I'm going to cover right here in this slide is only required for new communities after 2009. So a lot of our older communities, the board could simply have adopted a rule, sent it out, and said, this is effective, please comply. But what I've got on this slide is kind of our best practices. This is kind of what helps us to avoid challenges to rules. So what we often say is, all right, step one is identify the authority in your governing documents for this rule. Is it something that I'll give you an example of, in that I'll often talk with my clients about, well, what is this rule intended to regulate? Is it regulating behavior at the common area, say, for example, at the pool or in the park? That probably makes sense. It's within the governing documents. But if I want to reach onto somebody's lot or behind their door and adopt a rule that tells somebody what they can and can't do inside their home, and I'm going to give you the primary example, is rental restrictions and the time periods for rentals, we have to look to your governing documents to make sure that the association has the power to do that. And sometimes they do. Sometimes they do have the power to regulate rentals, but we have to make sure it's in your governing documents. Do you have the power? Next, draft it. Let's put together a draft. Think about the impact. Think about the scope, and let's put it down on paper. Now that we've got it down on paper, that's step two. And step three is get it out for comment. Get it to your community in a draft form. Invite people to send you comments. Invite a meeting to talk about it. What's next? Well, let's discuss in an open meeting all of the comments and what changes are appropriate. And that gets us to essentially a final version. And once we can then adopt that final version, we publish it and we get the notice out to everybody. So that's what we consider to be kind of the gold standard for that. All right, I'm moving on a little bit. One of the other concepts we talk about in this seminar is working with management. So we've put together a couple slides here, just trying to give the allocation. So this slide says board of directors. My next slide is going to say management agent. And so I've kind of talked about, well, what are the typical, and there's, that's just kind of what we see, but each community may find a different relationship works best with its owner. So the boards of directors typically sets the policy, adopts the budget. When I say adopt the budget, often the board doesn't actually do the first draft of it. Often the management company will do it or the finance committee will do it, but then the board ultimately adopts it. Oversight of the finances, whether the board is day in, day out addressing them or there's a finance committee that's watching them making recommendations. At the end of the day, the board of directors is ultimately responsible for that. Promulgating the rules. So what does that final rule look like when you implement it? Enforcement of covenants, rules and restrictions. So I'm going to say this is board level. I have a lot of communities where there's often a covenants committee or even an architectural committee that addresses violations. So each community is different, but do look at it. At the end of the day, the board of directors is often the top of that pyramid for enforcement. The board is also responsible for the final selection of contractors, managers, professionals, and finally oversight of the property. So what does that leave our management companies in? So this is assuming that you have a professional management company. Well, typically what the board of directors will have do is have the management company implement those policies. So once the policies are actually in place, let's take an enforcement policy that has a first notice of a violation and a second notice of a violation. Well, the board adopted the policy, and then the management company or the manager will then send out those notices according to the policy, because now they have the policy and they know what to follow. Handle the day-to-day operations and affairs. So that's meeting with the contractors on site, making sure that they're actually mowing where they're supposed to be mowing, receiving the bills, making sure the bills are presented to the board for approval and payment. The management companies will often manage the budget and the finances, and each company will have its own, expectations, and it'll find how it's going to work best with the company, whether we're going to have bank accounts, whether there's a local bank or faraway bank. There's a number of different ways to set up those processes. And then finally, we usually have the management agents do the oversee of the contractors and the professionals and the vendors. But again, this is just the typical allocation. Each community will find its own, and we encourage you to work with your management company to kind of find that. I think one of the questions just came in, who is responsible for identifying a violation? Should it be the manager or the board? And so there's no set way. I can tell you what I see most commonly as to violations. There's often a covenants committee that will do inspections, or they'll delegate to a manager to do an inspection on some weekly, sub-weekly basis. And then there's often a process by which a community will adopt a process where they can have a form that any owner can submit a complaint that says the property at such and such an address has a violation. So that's often what we'll see in regards to receiving violations. Okay, so we're getting in the home stretch here. One more slide here. We thought it make sense to put a slide here on how to consume legal services. So as you might imagine, there's no right or wrong way to consume legal services, but you should view the lawyer as outside counsel to the association. And keep in mind, our relationship is an attorney-client relationship to the association. The association is either the corporate entity or it's an unincorporated condominium association, but it's that entity is our client, but that entity talks to us via its board of directors. And keep in mind that board of directors changes over time. So the 5 people telling me what to do today will probably be a different 5 people than were telling me what to do last year. And just a quick warning, today's 5 people can say to me, Chad, I want to see every correspondence you sent to that prior board and why they did certain things, and they're entitled to it because my client is the association, speaks to me through the board, and the board can tell me what they want or not want, and there's no separate privilege between me and past board members. So do keep that in mind, that relationship, the way it goes. I often tell my boards, please think about and tell me, how do you want to consume legal services? Do you want to have a liaison? Do you want me to only talk to one board member, the president? Do you want me to only talk to the manager? Or do you want me to talk to the entire board at the same time via telephone or email? There's no right or wrong way. I often say boards are not expected to always be unanimous. They're not expected to always agree upon things. So some boards want to hear everything I have to say. Every board member wants to hear, which is perfectly fine. Just tell us how you want to do it, and we'll honor that request as we move forward. Some of the other things you can use lawyers for is interpreting the law, the governing documents, helping you limit liabilities, assess risk. As you might imagine, under COVID, we've been spending a lot of time assessing COVID risk, trying to implement procedures in place to manage risk, and we can represent the association in front of courts and in front of bodies. So that's kind of what we do. Let me see. Let me move on to meetings. So we're kind of in the home stretch on some of these concepts. In meetings, what I put on this slide is board meetings. So I really want to talk about board meetings, but do keep in mind there are different types of meetings. There is an owner meeting or an annual meeting where the membership votes, and that's typically where directors get elected. But once you're elected to the board, there is a board meeting, and the board meeting is for the board to conduct business, and the membership, while it's typically open and they're allowed to observe, they're not supposed to be participating. It's the board's meeting. And I know that I got a question in advance that some owners are very unhappy that they don't get to speak when they want to speak at board meetings, but that is the process. Meaning members elect you as directors, and then they expect you to go and do your work. So let's talk about what those meetings should look like. So there's open meeting requirements. The vast majority of Delaware communities have to have open meetings, but there are some older pre-Iowa communities that did not have to have open meetings. So look at your governing documents. Maryland, for the most part, almost always has to have open meetings as well. What are the best practices, even if you don't have to have open meetings, is still to have open meetings so that there's transparency to your membership. Oftentimes subcommittees don't have to be open meetings, so you can potentially break off into that. But I have a lot of questions about, well, it's just a working session to gather information. And I always discourage my boards from doing a working session that has enough members to be quorum, because that really could be a violation of the open meeting requirements. What I often say is open working sessions, which is not a phrase that's used in any of the statutes, is a concept that people use, and under Robert's rules, is supposed to be for accumulating information for the purpose of presenting it at the board meeting. So if you're putting together your charts and putting together your slides of how you're going to present something, that's perfectly fine. But if you're talking through the issues and I'm potentially trying to convince one director that they should vote yes or no on a particular issue, that's the type of discussion that should happen in an open meeting. So please do keep that in mind. I get a lot of questions about open meetings, and we do a lot of discussions about whether there has or has not been violations of open meetings. So what's the proper way to conduct a board meeting? I put proper here, but I think this is kind of like our best practice, our target, which is be prepared. Have everything ready to go. Shoot for no more than a 2-hour board meeting. I have some communities that are so excited they think they can get stuff done in an hour, and I've had some people who have told me their board meetings take 2 days. I can't imagine the 2-day ones. That must be very painful. But prepare the agenda. Have it ready to go. You potentially use outlines or scripts. I have a number of boards that say what they want to do is have the certain reports by committee submitted in writing, and they just kind of read them into the record, or they simply say, we've read it in advance, it's part, and you just kind of move on from there unless there's some type of decision that has to be made. Robert's Rules of Order is something that can be used. A lot of times board meetings are a little bit more informal, so we're not forcing people to make secondary motions and call to question. But if you have a contentious board, that is the way that you are able to essentially get the process done. And at the end of the seminar, I do have 1 or 2 slides on Robert's Rules, which is always a little bit dry, but usually helpful. For your board meeting, have a purpose. Make sure that you have to get through that agenda, get things done. What makes things helpful is written motions in advance, if they can be available to be attached to the minutes. This was the motion that was made. And then membership participation. The Delaware statute and the Maryland statute both require some sort of open forum. It doesn't say whether it has to be at the front end or the back end, but there is some component where you're supposed to open up the floor and let members that attended the meeting to give you comments. Board directors do not have to answer questions. That's not like an interrogation. You can simply say, thank you very much for your comment. I often have a lot of boards that'll set limitations on it, meaning you can only speak once, no more than 2 minutes or 5 minutes. So do consider putting those types of limitations in place if that gets abused at some of your meetings. And then finally, keep the meeting moving. If it's the chair of the meeting to say, hey, we're getting off tangent, we're talking about things that are unimportant, let's move on from here. And I think I just got a question during our board meetings. Can we give time for the community members to make comments and ask questions at the beginning? It's not part of our minute. Is this right to do and not document? So I think the question is it okay not to document what was said? And we're going to, I have a slide. It's coming up where we're going to talk about meeting minutes. And what's next? So we're good there. So let's just jump right to it. So meeting minutes, I get a lot of questions about that. And sometimes people send me their minutes and want me to read through them, and they're 10 pages. That's not minutes, that's notes. And there is a distinction. In our resort communities, I have a lot of communities that they want to take really detailed minutes because not all the members can attend the meeting. They want people to know what's going on. That's fine, but those are not minutes. Minutes under Robert's rules are very thin. It's just a record of what was said, not and of what action was taken. It doesn't have the detail of who said what and when they said it and how they went. All that's in there is what you see on the right of this slide, which is the type of meeting, the name, the date, the location, whether quorum was present, who was attended, and here's the meat of it. Actions taken on the minutes, officer reports, unfinished business, adjournment time, and the recording secretary's signature. So when we talk about like motions that pass, we just list the motion, write out the motion, what it was, that it was moved, seconded, and it passed with a 3-2 vote. And you don't have to have all the detail of who said what and what they said. Now, and the reason we encourage you to keep it that minimal is because when these minutes are adopted at the next meeting, they become admissions of the association. So be careful what you put into those admissions. Some communities choose to do notes, and the notes are much more detailed, but you don't adopt them later, and they don't become admissions of the association. So that'll give you something to chew on. Some communities choose to do really detailed minutes, and they're aware of that, and some choose to do very thin minutes. So it's your choice. Let's talk a little bit about executive sessions. So in both Maryland and Delaware, there's the option to go into an executive session. That is for the discussion of confidential nature. So let me talk about the logistics. How's the best way to go into executive session? I got another slide talking about what should we typically do in executive session. And that's the session where we kick out the owners and they don't get to listen to what we have to say because it's very confidential. We'll encourage you to schedule it, either the front of the meeting or the back of the meeting so that you don't have to kick people out multiple times throughout the meeting. But sometimes it happens because the way you're supposed to go into executive session is some director says, hey, the topic we're about to discuss is confidential. I make a motion to move into executive session. That's what I've got here on this chart. If that gets a second, then you vote on it. And if the vote passes, you go into executive session, you kick everybody out, you do your business, you'd make your discussion, and then you come back out of executive session. And the minutes should reflect what the subject was and when you went in and when you went out of executive session. So that's kind of what this slide is intending to do. That's the right way to do it. That's how your minutes should reflect it. I often get a question, should we have minutes from what was talked about in the executive session? And the answer is you can. You're not required to, but if you do, they need to be confidential and kept separate from everything else. So something to keep in mind. So let's talk about what can I go into executive sessions for? And this is the statutory list. I've kind of melded it, but you should think about it. It's oftentimes contracts that are under negotiation that if you release the information, it could become detrimental to the contract negotiations, and some other things like discussion of personnel matters, like you have an employee that's not performing, consultation with legal counsel, discussion of pending and probate litigation, something specific to one violation of a unit owner or a liability of a unit owner. So that's kind of our generic list. Now, what I would encourage you to do, though, is if you're going to use executive session, and almost every board should, you should be aware of what you can go into executive session for. Because if you're an old condo, your list under the Old Unit Property Act is a very small list. If you're a newer community, you have a much broader list, and then Maryland and has a separate list, and it's in statute. So you want to be really careful to make sure that you actually can go into executive session for the type of topic that you want to do. And I see a question in the chat box that says, are executive sessions usually just officers? So let me rephrase that question. Executive sessions are usually just directors, but they can invite other professionals in for the purpose of consultation. So for example, let's take the legal consultation. They can invite the lawyer to come to the executive session and give legal advice in that executive session. Or contract negotiation. They can invite one of the contractors in to ask questions about the specificity of their bid or something along those lines. So typically it's just directors, but they can invite outside professionals to give them advice as they need to. I saw another question. Does the board have an obligation to offer a virtual access to those that cannot attend the meeting? Great question. Both Delaware corporate and Maryland corporate law allow attendance by remote means, meaning you only have to be heard and be able to speak either by telephone or by video to be present at a board meeting. Now, keep in mind that is the corporate code. If you are an unincorporated condominium association, it's a little bit different based upon state law. So I'd say consult with your lawyer if you're a condo in Maryland or Delaware on that question. All right, so where are we on my slides? Rounding the corner, I only got a couple of minutes left. Use of emails can become really problematic, but that is the way of the world today. So be very careful that you're not using emails to bifurcate and skip the open meeting requirements, because it could constitute board action if you're kind of talking about a particular issue. But it does allow, both Delaware and Maryland allow for what we call unanimous consent. If you can't get together for a board meeting, but all 5 of you agree on an issue, and that's unanimous consent, you can use email to document that by unanimous consent and then essentially just ratify that at the next meeting. And I know I'm kind of skipping over that very quickly. There's some logistics in that are kind of worth talking about, but I can take questions on that later if need be. And then my last 2 sections of slides, I always do Robert's Rules of Order, and these are very dry. And given that I have 2 minutes, I'm just going to put them up on the screen and give you my general advice on Robert's Rules of Order. It's very formal, but it gets the job done. So if you have a very contentious meeting, whether it's an owner meeting or a board meeting, Robert's Rules may allow you to actually get your business done. Here's what I would encourage you to do, and I do it myself. Don't tell anybody. Well, I guess I've just told everybody. There's a massive amount of videos out on YouTube that talk about Robert's Rules of Order and go through the most common motions and how to handle them, and to teach you how to be a good chairman. And they're dry and they're terrible to watch. I sometimes put them on my audio when I'm driving and just listen to them, and it really kind of helps you understand, well, when does this motion come into play and how do I call the question? And so, if you're the one running the meeting, you may want to, spend some time on Robert's Rules. And then my last slide of the day, which is, well, if I didn't listen to you at all, how can I go about getting the association as much trouble as I can? So I've put together that slide for you. So here's my top 9 little things of what you can do if you really want to get the association in trouble. So, and I'll just read through them. Don't read your governing documents. Don't prepare for board meetings. Don't understand what your role is as a director. Forget that when you speak, you're heard as a director authoritatively for the association. Act without board authority. Meaning, think that as a director, you can tell people what to do as the board when you really can't. Assume rights or privileges others do not have. Make it a personal dispute. Fail to listen to the members, and do not recuse yourself from matters in which you have an interest. So that was really the end of my slides. I want to thank Christine and Rachel, and also Molly is on our phone. Rachel and Molly from our marketing department. Christine is in our paralegal in our Delaware office are just amazing. They pulled all this together very quickly. So I think it went very smoothly. So thank you very much for helping organize that. And I wanted to thank everybody for participating. And please do send me comments and thoughts. Should we do this again? Should we do a different subject? Should we take this one and get a little deeper? We were honestly shocked by the amount of participation. So clearly we tapped into something that people want. So maybe we can take it and go a different direction. But with that, thank you to everyone. I appreciate everybody's time. And I guess, Christine or Rachel, I'll leave you guys to handle the technology.
Sounds good. Thank you all so much for coming this evening. We appreciate it. And we will circulate the slides to you all probably sometime tomorrow later this week. But thank you all and hope you have a great night.